Good day, Crime Talk aficionados. It's Sunday, but it means we're bringing you a weekly recap of all the top stories throughout the week, all conveniently located in one location. I hope you enjoy it. I hope you watched every program, but watch it again. We appreciate it. Thank you. Enjoy, and remember, the Constitution matters.
All right, lawyer.
First on the docket, who do we have? Barry Morphew. That's right. The man previously accused of killing his wife, Suzanne Morphew, was arrested in Gilbert, Arizona, following a new grand jury indictment issued out of Alamosa County there in Colorado. Now, the Arizona Department of Public Safety officers apparently acted swiftly, taking Morphew into custody within just minutes of the indictment being issued. Now, Friday, Morphew was booked into the Maricopa County Jail, where he is going to be extradited back to the state of Colorado and face the charges of first-degree murder. He is not fighting extradition, which I always found that funny. Really, the only basis for which you can fight extradition is saying, that's not me. That's what in federal court, they refer to it as a identity hearing. Is this the right person? Some people always try to get cute. I'm going to fight extradition. Maybe if you're in a foreign land, it's a little more difficult. Here in the United States, it's pretty straightforward. So for those who are not familiar with this case, because it's going to be a big one, ladies and gentlemen, Suzanne Morphew disappeared on Mother's Day back in 2020 from her home in Salida, Colorado. Now, although Barry Morphew was charged in connection with the disappearance, the case, lacking a body at the time, was dismissed by a judge in 2022 after the case was rife with prosecutorial misconduct and just, frankly, sheer incompetence. That's my opinion. The prosecuting attorney, the elected district attorney, Linda Stanley, was ultimately disbarred for her conduct in that particular case as well. So it is a type of situation where hopefully they'll get it right this time. Anyway, ultimately the charges were dropped. Morphew relocated to Arizona. He was living in a trailer at the Stardust Trailer Park in Cave Creek. I have this handy, but I'm not going to read it today, but it is the autopsy report. Obviously, you got the gist of it from the indictment, basically saying that obviously it's murder. They just don't know how for sure, and they're throwing this out there. Obviously, one of the arguments the defense will make, hey, if the prosecution doesn't know how it happened, how do you expect the defense to know how it happened? Obviously, like so many cases these days, you've got cell phone data, as it relates to when phones were on, when they're off. Obviously, this really came to light. I mean, obviously, it's been there forever, but in the Alec Murdaugh case, just had it in the Karen Reed case. I guess you can take it for what you want. It's either accurate or not. But, every time you wake up your phone and, do something on there, yes, it saves it. You put it down, it goes to sleep. You open an app. All that information is available. Now, I think, the significant thing is the prosecution will argue is that why is the phone off during these particular times that coincidentally happen to be where she's supposedly missing and doesn't really coincide with the story that you told police as it relates to when you were, where you were when your wife was missing. I think generally most people don't turn their phone off. However, that alleged crime, he's given the presumption of innocence, obviously, Barry Morphew is, but the alleged crime is in Salida. If anyone's ever been up to the Salida area, you have areas that you don't get very good cell reception. So I'm sure the data will show whether it was on with no cell reception or actually powered off. Most people don't go around turning off their cell phone unless maybe they're getting on the plane. I don't turn off my cell phone. Just because I don't turn it off unless I need to reboot my phone. So something to think about. Obviously, we've got a long way to go. Barry Morphew is not using his original attorney, as I understand it. Iris Itan, who was the lead attorney, and Drew Nielsen. That law firm has since split up. They went their separate ways, both very skilled attorneys. And as I understand it, they have hired Recht and Kornfeld. And it looks like David Beller will be their lead attorney on that case. David Beller is a very fine attorney, very good. Started out at the public defender's office. I remember seeing him at the public defender's office in Adams County. He went to work for Recht and Kornfeld, and he's a very good attorney, very skilled attorney, and we'll see how he does. I wish all parties, like I said, Fred Johnson, one of the prosecutors on the case, I've dealt with him numerous times over the years. He's a good guy. Straight shooter has always been my experience. I don't know Ann Kelly, at least not by name. Maybe if I saw her face, but it doesn't ring a bell. And obviously David Beller and whomever he brings in for his co-counsel, very fine attorneys. It's going to be another good showdown. Now, he did put out statements basically saying same evidence, same result, or will be the same result. So we'll see. We'll see how things go in the Barry Morphew matter. We'll certainly bring it to you. Last time they were there, Julie worked for us, and we sent her down to cover the hearing. Remember that, Frank? That was exciting time. And she came back, and I think at first, I remember her thing was after the preliminary hearing was that she was convinced that he was guilty. But then she heard the evidence or the lack thereof, and she goes, well, I don't know. Maybe he didn't do it. So it just goes to show you have to have an open mind, and we'll see where things go. To Bryan Kohberger, more out-of-state witnesses in the Bryan Kohberger matter have been identified. Now, the necessity of out-of-state witnesses for Bryan Kohberger's trial in the University of Idaho student murders case underscores their critical role in ensuring a fair and comprehensive judicial process, right? Well, two additional Pennsylvania residents, William Searfoss and Anthony Soma, have been summoned to testify, joining 5 other Pennsylvanians required to attend a hearing to determine whether they must travel to Idaho for the trial, which is obviously set to begin in August, assuming the judge does not grant the defense's continuance request. Now, Searfoss, a correctional officer at the Monroe County Correctional Facility, well, he was there when Bryan Kohberger was detained following his arrest back in December of 2022. And Soma, whose connection to Kohberger remains somewhat unclear, are among those whose testimony is deemed essential. Now, Searfoss, who may provide insight into Kohberger's behavior or interactions during his detention, is apparently vital to both the prosecution and the defense to present a complete picture of the case. Other Pennsylvania witnesses, such as Kohberger's former boxing coach, a school advisor, and a professor who recommended him for the PhD program, are expected to testify in regards to his character, academic background, and prior conduct. Now, that would be more for the sentencing phase if it gets there. Obviously, he's entitled to the presumption of innocence. Now, those witnesses' perspective could be crucial for contextualizing Kohberger's actions and state of mind, which obviously could influence potentially the trial outcome as it relates to whether guilty or not guilty. And obviously, if it gets to the sentencing stage, whether Mr. Kohberger is sentenced to death or he is given a life without the possibility of parole sentence. Now, compelling these witnesses to travel across the country highlights the court's recognition that their firsthand knowledge is indispensable for thoroughly examining the evidence. For instance, the prosecution intends to use Kohberger's academic work from DeSalle University to demonstrate his familiarity with crime scene handling. At the same time, the defense may rely on these witnesses to support their narrative. The necessity of their presence in Idaho ensures that the trial addresses all relevant aspects of Kohberger's past, which is essential for delivering justice in these high-stakes cases involving 4 counts of first-degree murder and 1 count of burglary. Now, you may say, gee, why do you have to bring somebody into court in Pennsylvania to go to court in Idaho? Well, remember, the court in Idaho has no jurisdiction over somebody in Pennsylvania. That subpoena is not worth the piece of paper it's written on. So you have to basically go through this process. There's an act. It's like the Interstate Rendition Act. And you have to basically go to the prosecutor or local attorney, get the matter set, serve the witnesses, set a hearing date, and then the judge in Pennsylvania will order those witnesses to cooperate and appear at the time scheduled. And obviously the state of Idaho or the defense, whomever is bringing them, will have to pay for their travel expenses and everything related to their time in Idaho. But that's necessary because, like I said, if I were to issue a subpoena, it is not worth a piece of paper it is written on to, let's say, a California corporation. They're going to say, well, you didn't comply with this act, and under California, you don't have to do that. So you have to get basically a judge to sign off on it and say, I'm ordering you. This is important. Now go to a judge in California to do it. It's a pain in the butt, but that's the thing, is that we are separate states, and, I shouldn't be subjected to criminal actions in, let's say, I don't know, Alabama if I've never been there, and nobody can certainly make me go there as a witness unless I voluntarily did that. Now, none of these witnesses are apparently volunteering and saying, give me a waiver of service and I'll sign it and I'll promise to get on that airplane. We'll see. That hearing's obviously coming up in the next couple of days. The judge will order them to appear. Not a big deal. The biggest thing is going to be, are we starting on time in the Kohberger matter, which I believe it is. I don't believe Judge Hippler is going to grant a continuance based upon his statements at the last hearing just a couple of weeks ago, which would also mean that the third-party suspect, third-party perpetrator, probably not going to be allowed to be introduced by the defense. Doesn't really matter. Obviously, the defense still has to be able to cross-examine these witnesses, and they can still say, hey, in the course of your investigation, you collected some other DNA, didn't you? Whether they go into testing or not, still throws it out there that it goes to the weight of the investigation. The jury can decide what weight to give it. Frankly, I think that's a better strategy than trying to go with a third-party suspect, unless you can actually prove, i.e., via a confession, that somebody else committed the crime. Next, the defense challenges the prosecution in the Mangione case. That's right, they're not happy. So in letters addressed to the judge there in New York Supreme Court, the defense team for Luigi Mangione, charged in the indictment, has raised serious objections to the prosecution's conduct in the high-profile case. Now, the defense's reply, submitted in support of an omnibus motion, outlines 4 primary concerns: the public release of Mangione's alleged journal, unsupported terrorism charges, the scheduling of the state trial before a federal death penalty case, and the need for a motion scheduled to address procedural demands. So let's go through a quick summary of their key points and their implications. First, the public release of the alleged journal. The defense argues that the prosecution has prejudiced Mangione's right to a fair trial by publicly releasing his alleged journal, described as a diary by the prosecution, but repeatedly referred to as a manifesto in their filings. Now, the defense contends that this release was unnecessary, as the journal is already a part of the grand jury evidence, and a MAP hearing to determine the legality of the search of Mangione's backpack has been consented to. They assert that the selective release of potentially inadmissible material aims to bias public opinion against Mangione, particularly significant given this his concurrent federal death penalty case. Now, the defense cites their local rule of the Southern and Eastern Districts of New York, which prohibits the release of prejudicial information likely to be inadmissible, emphasizing the rule's relevance to Mangione's federal case. The next point they want to bring up is the unsubstantiated terrorism charge. Now, defense challenges the prosecution's terrorism-related charges, specifically murder in the first degree, as an act of terrorism, arguing they lack legal and factual grounding. They refute the prosecution's claim that Mangione's alleged actions alone demonstrate terroristic intent, noting that alternative motives, such as targeting the victim for a specific action at the United Healthcare meeting, are plausible. The defense also disputes the prosecution's reliance on Mangione's private journal entries, asserting that these reflect personal grievances rather than an intent to intimidate or coerce a civilian population, as the New York Penal Code requires. Now, they further argue that any public response, such as threats against insurance workers, stems from the prosecution's public disclosures rather than Mr. Mangione's actions. The defense emphasizes that the terrorism charges require an intent to harm multiple individuals, citing various precedent, like the case of People v. Morales, and notes that the United States Attorney's Office did not charge Mangione with terrorism, undermining the state's position as well. Their next point is that the state trial scheduling conflicts with the federal case. Now, the defense contends that the proceedings with the state trial before the federal death penalty case violates Mangione's constitutional rights. They argue that the simultaneous prosecution for the same incident with differing charges and defenses burdens Mangione, who must participate in his defense while managing extensive discovery, roughly about 9.7 terabytes according to the defense. and then obviously preparing for a complex federal case as well. Now, the defense highlights that no modern precedent exists for a non-capital state prosecution proceeding a federal death penalty case, and they compare the case's timeline to other New York murder cases, which took years to reach trial, and criticize the prosecution's push to accelerate the proceedings. Now, the defense also warns that testifying in the state case could prejudice Mangione in the federal case, where his testimony could be used against him in the capital context, invoking the supremacy clause to prioritize federal protections. That's right. Remember, federal law trumps state law, supremacy clause. Interesting argument. Anyway, and fourth, the defense requests for motions scheduling. The defense requests the court set a motion schedule to address the prosecution's demand for notice under the local rules, which relates to psychiatric defenses. They argue that the prosecution's rush to expedite the case disregards the court's prior guidance and risks procedural errors, and the defense maintains that they will not yet serve their requests notice to avoid prejudicing Mangione's rights, particularly giving double jeopardy concerns raised by concurrent prosecutions. They cite to a case to argue that dual prosecutions for the same offense violates fairness principles, urging the court to establish a schedule that considers these constitutional issues. Interesting issue. Don't think that's going to float. Separate sovereign. They can charge you even if it's the same factual basis. I understand their frustration. It would make sense for the death penalty case to go forward, because then you can basically fall back on the state case if something goes wrong on appeals. But the feds wanted to go first because they get to see the state present their evidence. There must be some strategy to that, i.e., is Mangione going to have to testify? It's basically a mess. But guess what? Somebody's got to go first. Death penalty case, obviously, we've seen in the death penalty cases, they take much longer because of all the mitigation. Fortunately, though, his attorneys are the same, so they should be ready to go. But eventually, guess what? Some case is going to have to go first, and the judge will ultimately decide. Complicated issues, but it's not that complicated of a case, in all honesty. The prosecution has to prove identity. And guess what? The diary, the notebook, the manifesto, whatever you want to call it, did the prosecution have to publish that? It's not like they released it to the press. It was in a filing made public to the court. That's how it was put out there. But that is the evidence in the case. And heck, the way things are going with Luigi Mangione, it could help him with a jury in New York. Who knows? Who knows what's going to go on in New York, right? You never know. Anyway, the defense letter underscores, obviously, these tensions between the state and federal judicial process, particularly in cases involving severe penalties like, the death penalty. It raises questions about prosecutorial discretion in managing public information and the potential for prejudicing a defendant in a high-profile case. And the reference to prior threats against the United Healthcare CEO disclosed in the grand jury testimony suggests a broader context of public frustration with the insurance industry, which the defense argues the prosecution has exploited to bolster its case. Who likes insurance companies? Insurance companies are probably some of the most horrible corporations on earth. If you've ever dealt with an insurance company, right, they want your money. They want you to sign immediately. And then they don't want to cover claims, or they want to settle for minimal amounts of money. If you're talking about a jury nullification, my God, could this be the case? Possibly, because everybody hates insurance companies. And if they can make the CEO look like a real dirtbag, go to the jury nullification defense of that guy deserved killing. And I'm not saying he deserved killing. Nobody deserves to die like that, being shot in the back by allegedly Luigi Mangione. But, juries are mysterious things. You never know what a jury will do. Literally, you never know what a jury may do. Anyway, the court's response to these arguments could set significant precedents for handling dual prosecutions, as well as protecting a defendant's fair trial rights in cases, obviously, where there's extensive media coverage. And obviously, Mangione's defense team is pushing for a measured approach to ensure that their clients' constitutional protections are upheld, amidst what they described as a prosecutorial overreach. Next on the docket, let's talk about Suzanne Morphew and her disappearance. All right, now a lot of people either didn't know about this case or maybe have forgot about it. So let's give a quick recap. So Suzanne Morphew, May 6th, all right, she sent a text message to her husband, Barry Morphew, stating, "I'm done. I could care less what you're up to and have been for years. We just need to figure out how to do this civilly." May 10th, Suzanne Morphew was last seen. Barry Morphew informed the detectives he last saw his wife about 5 a.m. just before he left for a landscaping job in Broomfield, Colorado, which literally 3 miles down the road from my office here. Okay. My airplane hangar is in Broomfield, Colorado. Frank, the hardest working man in show business, lives in Broomfield. My son went to Broomfield High School, for goodness sakes. Okay. Anyway, nice little wholesome little town there, right? So that's where he was going to be. Anyway, a neighbor reported Suzanne missing after she failed to return from a bike ride on Mother's Day. Now, police located her blue mountain bike with no blood evidence nearby. And a deputy noted that the bike appeared to be deliberately placed, raising suspicion of some sort of criminal activity. Now, I'm not really sure how you could say it was deliberately placed, like, oh, I'm going to lay it down here, or you send it over. Seems like speculation. Probably the officer's opinion at trial will not come in. Just say, how did you find it? Try to get it in, I guess. Did it appear to be deliberately placed, or was it just there naturally? Objection, speculation, sustained, move along. Next, a large-scale search was initiated involving the Chaffee County Sheriff's Office, the FBI, and the Colorado Bureau of Investigation. Then on May 13th of 2020, investigators found Suzanne Morphew's bicycle helmet approximately 0.84 miles from her bike. On May 14th, Barry Morphew posted a video on Facebook pleading for his wife's safe return, stating, "Oh, Susan, if anyone is out there that can hear this, that has you, please, we'll do whatever it takes to bring you back. We love you. We miss you. Your girls need you." Then on May 5th, 2021, Barry Morphew was arrested and charged with first-degree murder, attempting to influence a public official, and tampering with physical evidence. He enters a plea of not guilty. Then through a lot of mess as it relates to the prosecutors and their discovery, which ultimately resulted in the prosecutor, Linda Stanley, the first, wound up getting disbarred because of how poorly she handled the Barry Morphew case. And so then on April 19th of 2022, a Colorado judge dismissed the charges against Barry Morphew without prejudice due to prosecutorial misconduct, allowing the potential for future charges. And as you may remember, the prosecutor got up there and said, "We know where she's buried. We'll find her." And every time I flew over that stretch of land, I just wonder if they're down there looking for Suzanne Morphew. Anyway, the Colorado Bureau of Investigation located Suzanne Morphew's remains in Moffett County, right there on the line, also of Saguache County. Now, it's spelled Sagauhe or something along those lines, but it's pronounced. I've had people call my office, which I appreciate. Let me know it's pronounced Saguache. Apparently, the Saguache Indian tribe. I lived in Colorado all my life. It doesn't come up very much in conversation. The pronunciation of Saguache or Saguache. Saguache it is. We'll take their word for it. Okay. Next, on April 19th of 2024, an autopsy determined that Suzanne Morphew's death was ruled a homicide with the BAM intoxication detected in her body. Anyway, all these tranquilizer medicines that they refer to as BAM, it was detected in her body. Then on June 20th of this year, a grand jury indicted Barry Morphew for first-degree murder in the death of Suzanne Morphew. He was arrested in Phoenix, Arizona. Prosecutors stated that Barry Morphew used BAM, a tranquilizer, for sedating and transporting deer to his deer farm. That was back when he lived in Indiana, and was the only individual in the surrounding counties with a BAM prescription between 2017 and 2020. I'm not sure how they're going to narrow that down. It's going to be interesting because, I don't know, what if another guy from Indiana just happened to have his BAM prescription, and how would they know that he didn't have it? I don't know. Maybe that goes to reasonable doubt. We'll have to wait and see. Anyway, Barry Morphew's attorneys stated that Mr. Morphew maintains his innocence And the prosecution's has not had a whole lot of comment other than they're going to do it right this particular time. Now, Mr. Beller, who I know, he's an acquaintance professionally. It's not like we hang out or anything. Very fine attorney. He did say early on that it's the same charges, same evidence. It's going to be the same result. I always found it's very, very good not to make, yes, my client maintains his innocence, that kind of thing. We're going to fight this case in the courtroom, not in the media. Otherwise, you could wind up being a little humble pie. You got to be a little humble as a defense attorney. Why? Because you got to make sure, everybody's telling you the truth. Let's just put it that way. Because there were some major rulings that came out yesterday evening. They were posted on the court website as it relates to the Bryan Kohberger matter. And let's just say Bryan Kohberger has been dealt a huge blow to his defense after an Idaho judge slapped down his efforts to point the finger at 4 alternate suspects, blasting his legal team's evidence as entirely irrelevant and wild speculation. So in a scathing order handed down Thursday afternoon, Judge Stephen Hippler blocked the accused mass killer's defense from presenting evidence to the jury at his capital murder trial, alleging that these mystery individuals and not Bryan Kohberger could in fact be the real killers. Anyway, this marks, like I said, a major defeat for the Kohberger defense strategy in a case where the prosecutors are obviously seeking the death penalty for the brutal murders of Xana Kernodle, Etha Chapin, Kaylee Gonzalez, and Madison Mogan. In the order, Judge Hippler hammered the defense, saying that the evidence presented to the court was entirely irrelevant and that the attorneys had not shown a scintilla of competent evidence connecting the 4 alleged alternate suspects to the crime. Now, I could leave it right there. Could I not? But why would I do that, ladies and gentlemen? Because we want you to have all of the information. So whether you're obviously rooting for the prosecution, and many people are, understandably, there was a horrendous quadruple murder that took place, and people want to see justice is done. Then you got a lot of people in the Kohberger argument that think that he is being railroaded in some particular way. But the reality of it is, you need to understand the court's complete order. I can simply say, well, the judge denied the motions and it was kind of embarrassing. But you need to know the context as to what the defendant was arguing and the evidence that was raised. At least we find out a little bit more about it.